Most people assume that once a house is paid off and a will is written, the home is protected. They imagine their spouse will simply keep living there, or their children will inherit it smoothly, and that a lifetime of mortgage payments has secured the family's future. But there is a quiet problem that sits inside millions of American homes right now. It has nothing to do with unpaid bills or bad credit. It is not a scam, and it is not a lawsuit. It is a paperwork problem. Specifically, it is a deed problem. And for the families who discover it, the discovery almost always comes at the worst possible time. Right after someone dies, right when a surviving spouse is grieving, or right when adult children are trying to honor their parents' wishes. Here is what most people do not realize. Your will says who you want to receive your home, but your deed controls who actually gets it. And if those two documents are not aligned, the deed usually wins. The will may not even matter because property law handles your home before the will ever reaches probate court. There are specific ways a house deed can be written, some that protect your family, and some that quietly send them straight into a probate process that can take months, cost thousands of dollars in legal fees, and freeze the home entirely during that time. A surviving spouse can find themselves unable to sell, refinance, or even make repairs on a home they have lived in for decades, all because of how the deed was written years earlier. If you own a home, or are helping an aging parent who does, this is a conversation worth having right now before anything changes, before there is a crisis. Stay with me, because by the end of this, you will know exactly what to look for, what the mistakes are, and what questions to ask before any problems become permanent. According to data from the American Bar Association, probate is one of the most common legal processes families face after a loved one dies. And in a significant number of those cases, real estate is what triggers the process or makes it more complicated. For seniors and retirees, the home is often the single largest asset they own. In many cases, it represents decades of work, equity built slowly over time, and the one thing they most want to protect for a spouse or leave to their children. And yet the deed, the document that legally defines who owns the home and how, is something most homeowners have not reviewed since the day they bought the house. Rules vary by state. Deed types vary by state. What protects a couple in Florida may not protect the same couple in Texas. And the mistake that seems harmless when you are healthy and retired can become an expensive legal problem the moment one spouse passes away. This video is not legal advice. Every family situation is different, and deed changes should never be made based on a video alone. Use this as a checklist of what to ask and what to review with a qualified attorney in your state. The goal here is awareness, so that no one in your family discovers the problem too late. Let's begin with a story. A retired couple in their mid-70s, a man named Gerald and his wife Patricia, owned their home outright. They bought it in 1987, paid it off in 2009, and had lived there for nearly 4 decades. Gerald had written a will. It left everything to Patricia, and after her to their 2 adult children. He was thorough. He was organized. He had done what most people think of as the right things. Gerald passed away in the spring. Patricia assumed she would simply continue living in the home they had shared. What she did not know was that the deed had been written decades earlier as a tenancy in common. A deed type that, unlike others, does not automatically pass Gerald's share of the home to her. Instead, his share became part of his estate, and that meant probate. Patricia, at 74, suddenly found herself in a legal process she did not expect, could not fully understand, and could not afford without help. The home was frozen. She could not sell it, could not take equity from it, and had no legal clarity about her full ownership while the process dragged on. It took 11 months, several $1,000s in legal fees, and a tremendous amount of emotional stress before it was resolved. Gerald had no idea his deed could cause this. Neither did Patricia, and that is exactly why this matters. Let's start with the foundation. What is a deed, and why does it have this much power? A deed is a legal document that establishes who owns real property and how they own it. When you buy a home, a deed is recorded with your county or local government, and that recorded deed becomes the official record of ownership. The deed is not your mortgage. The deed is not your homeowner's insurance policy. The deed is not your will. The deed is its own separate document, and it operates under its own set of rules. What many people do not understand is that the deed controls what happens to your home at death, often entirely on its own, before a will is ever considered. The way a deed is worded, specifically who is listed and what type of ownership is described, determines whether the home passes automatically to a surviving spouse, whether it goes through probate, or whether ownership splits in a way the family never intended. Here is the part that surprises most people. Even if your will says, "I leave my home to my wife," that instruction cannot override a deed that is not properly structured. The will speaks to the probate court. The deed speaks first. Now let's talk about the different ways a deed can be written and why the difference matters enormously. The first type is called joint tenancy with right of survivorship. This is one of the most commonly recommended deed structures for married couples, and for good reason. When a home is held in joint tenancy with right of survivorship and one owner dies, the surviving owner automatically becomes the sole owner. There is no probate for that transfer, no court involvement, no months of waiting. The surviving spouse typically files a simple affidavit of survivorship with the county recorder, attaches a copy of the death certificate, and the title transfers. This is what most married homeowners believe they have, even when they do not. Because many couples purchased their home years or decades ago, when the deed was drafted by a title company or real estate attorney, the specific language used may not have included the right of survivorship wording. A deed that simply says John Smith and Mary Smith, without explicitly stating how ownership is held, can default to a different type entirely, depending on your state. That different type is called tenancy in common, and this is where families get into trouble. With a tenancy in common deed, each owner holds a percentage interest in the property. That interest does not automatically transfer to the other owner at death. Instead, the deceased owner's share becomes part of their estate. It passes according to their will if there is one, or according to state intestacy laws if there is not. For a married couple, this can mean that the surviving spouse does not own 100% of the home after their partner dies. They may own 50%, while the other 50% is stuck in probate. Or, in a blended family situation, a deceased spouse's share might pass to children from a prior marriage, leaving a surviving spouse legally sharing the home with stepchildren who may have very different ideas about what to do with the property. This is not a rare edge case. This happens. And it happens because the deed language was never reviewed. Think about what this means in practical terms. The surviving spouse still lives in the house, but they may not have the legal authority to sell it, to refinance it, or to use the equity without the consent of co-owners who are now part of the title. If there is a disagreement among those co-owners, which in blended families is not uncommon, the home can become the center of a legal conflict while the grieving spouse is still living inside it. The consequence here is not just financial, though the financial cost is real. It is deeply personal. It is the loss of stability, the loss of certainty, and the loss of the one thing a surviving spouse was counting on as a foundation. There is a third deed option that is available in many states, and that senior homeowners in particular should know about. It is called a ladybird deed, or in formal legal language, an enhanced life estate deed. This type of deed is not available in all states. As of now, it is recognized in a handful of states including Florida, Michigan, Texas, West Virginia, and a few others. So you will want to confirm whether it applies where you live. Here is how it works. The homeowner keeps full control of the property during their lifetime. They can sell it, mortgage it, or change their mind without needing permission from anyone. When they die, the home passes automatically to whoever is named as the beneficiary on the deed, without probate. Unlike a simple life estate deed, the owner retains the right to revoke or change the beneficiary at any time. Why does this matter for seniors? A few reasons. First, it avoids probate on the home entirely. Second, in states where it is recognized, it may help preserve Medicaid eligibility by not counting as a transfer of assets in the way some other deed changes might, though this area of law is complex and varies significantly, and any Medicaid planning involving a deed should absolutely be reviewed by a qualified elder law attorney before you act. Third, it keeps the owner in control during their lifetime, which a traditional life estate deed does not always do. If you live in one of the states where a ladybird deed is an option, and you have not explored this with an attorney, it may be worth a conversation. The next mistake is one that appears on the surface to be thoughtful planning, but that can backfire in ways that cause enormous family stress. This is the mistake of adding a child's name to the deed. It seems like a logical thing to do. A parent wants to make sure their child inherits the home. They want to avoid probate, so they go to the county recorder's office or use an online form and add their son or daughter to the deed as a joint owner. Problem solved, they think. But here is what actually happens. When you add someone's name to your deed, you are making a legal gift of partial ownership. That means a few things that most people do not expect. First, that child's interest in the home can now be reached by that child's creditors. If your son has a lawsuit against him, a judgment against him, or goes through bankruptcy, that judgment creditor may be able to place a lien on the home, your home, because your son legally owns a portion of it. Second, if you want to sell the home or refinance it, your child must now agree and sign. If you and your child disagree, if your child goes through a divorce, or if the child's circumstances change in any way, your ability to control your own home has been legally reduced. This is the part that catches people off guard. You thought you were protecting your future, but you may have handed over a piece of your present. Third, there is a significant tax consideration that many people are never told about. When you leave your home to a child through your estate at death, the child typically receives what is called a stepped-up cost basis. That means for capital gains tax purposes, the value of the home is reset to its fair market value at the time of your death. If your child later sells the home, they may owe little or no capital gains tax on the appreciation that happened during your lifetime. But if you add your child to the deed while you are alive and they receive ownership as a gift rather than an inheritance, that stepped-up basis may not apply. Your child's cost basis could be the original purchase price from decades ago, not the current value. If the home has appreciated significantly, and in many parts of the country, older homes have appreciated dramatically, that could result in a substantial and entirely avoidable capital gains tax bill when your child eventually sells. This is a tax consequence that real estate attorneys and estate planners see regularly, and it catches families completely off guard because no one told them at the time they made the deed change. Let's talk about what happens after a divorce, which is a situation that affects many older American families either directly or through their adult children. When a home is held jointly and a couple divorces, the deed does not automatically change. The divorce decree may say who gets the house, but until a new deed is recorded reflecting the new ownership, the original deed remains on file. This matters for a few reasons. If the divorce decree awarded the home to one spouse, but the deed still shows both names, the title is not clear. If that spouse later wants to sell, the title company will see the original joint ownership and require resolution. If the other ex-spouse is difficult to locate or unwilling to cooperate, clearing the title can become a significant legal process. For older Americans, this situation sometimes arises not with their own divorce, but with a deed that was updated after a child's divorce to add a son-in-law or daughter-in-law to the title. That person is now listed on the deed to your property. If that marriage ends, your home's title is now caught up in the fallout. The lesson here is that deed changes should be made carefully and only with legal guidance, and that existing deeds should be reviewed regularly, especially after major life events like marriage, divorce, death, or remarriage in the family. Here is a scenario that many people who have been widowed will recognize. A homeowner passes away. The surviving spouse, believing the will covers everything, simply continues living in the home without taking any legal steps to update the deed. Weeks turn into months, months turn into years, and the deed still shows the deceased spouse as one of the owners. This becomes a problem the moment the surviving spouse needs to act on the home. If they want to sell it, refinance it, use a reverse mortgage, or even establish a home equity line of credit, the title company or lender will conduct a title search. That search will show a deceased person on the deed. The transaction cannot proceed until the ownership is legally resolved, which, depending on the deed type and the state, may require a court process. In some states, if the deed was joint tenancy with right of survivorship, this process is relatively simple. File an affidavit of survivorship with a death certificate, and the title updates. But if the deed was not written with survivorship language, it can require probate of the deceased spouse's estate even years after the death. And in some states, waiting too long to address this can create additional complications. The practical advice here is straightforward, but important. If you have lost a spouse, or if you are helping a parent who has, do not wait to review the deed. Even if there are no immediate plans to sell or refinance, getting the title clarified while the process is straightforward is far easier than dealing with it under pressure when a transaction or a health event requires it. There is one more area to understand, and it involves what is sometimes called a transfer on death deed, or a beneficiary deed. This is a relatively newer option that has been adopted by many states, though not all, that allows a homeowner to name a beneficiary directly on the deed, similar to how you would name a beneficiary on a retirement account or life insurance policy. When the homeowner dies, the home transfers automatically to the named beneficiary without going through probate. During the homeowner's lifetime, the beneficiary has no rights to the property. The homeowner can sell it, mortgage it, or change the beneficiary at any time by recording a new deed. This tool, where it is available, can be a simple and effective way to avoid probate on a home. But like all deed strategies, it should be reviewed with an attorney before you act, particularly if you have a spouse, multiple potential heirs, a blended family, a child with special needs, or any Medicaid planning considerations. The simplicity of the tool can sometimes create complications in situations that are not straightforward, and in some states, the rules around transfer on death deeds are still evolving. Now here is what you can do. Not tomorrow, this week. The first step is to find your deed. In many cases, you were given a copy at closing when you bought the home. If you cannot find it, contact your county recorder's office or county clerk's office. In most jurisdictions, recorded deeds are public records, and you can request a copy. Some counties have this available online. Knowing what you have is the foundation of everything else. The second step is to read the ownership language on the deed carefully. Look at how the owners are listed. If the deed says John Smith and Mary Smith as joint tenants with right of survivorship, or as husband and wife with right of survivorship, that language may be protective. If it simply says John Smith and Mary Smith without any survivorship language, or uses the phrase tenants in common, that is a flag worth discussing with an attorney. The third step is to ask whether your deed type matches your current family situation. Life changes, people remarry, spouses pass away, children are added, people get divorced. A deed that made sense when the house was purchased in 1994 may not reflect the reality of your family today. This review is not about changing the deed immediately. It is about understanding whether what you have is still appropriate. The fourth step is to ask about your state's specific options. Some states offer joint tenancy with right of survivorship. Some offer tenancy by the entirety, which provides additional protection for married couples in certain states. Some offer transfer on death deeds or beneficiary deeds, Some recognize the ladybird deed. The tools available to you depend on where you live, and an elder law attorney or estate planning attorney in your state can walk you through the options that apply to your situation. The fifth step, and this one is critical, is to make sure your deed and your will are telling the same story. Your estate plan is not just one document. It is a collection of documents that should work together. If your will leaves the home to your spouse, but the deed sends it somewhere else, there is a conflict. And in that conflict, the deed usually wins. Having an attorney look at both documents together is far more valuable than reviewing them separately. Finally, if you have already added a child's name to your deed without legal guidance, or if your deed still lists a deceased spouse, or if there is any title issue you have been meaning to address, make those appointments now. These are not emergencies until they become emergencies. And by then, the options are fewer and the costs are higher. Let's bring this together. The home you own is very likely the most valuable thing your family has. And the document that controls what happens to that home at death is not your will. It is your deed. The deed type, whether joint tenancy, tenancy in common, a transfer on death structure, or another form, determines whether your spouse gets the home automatically, whether your children inherit it cleanly, or whether your family ends up in a probate process they were never expecting. The most common mistake is simply not knowing what the deed says, and assuming that a will or a handshake promise is enough. It is not. The second most common mistake is adding a child's name to the deed without understanding the gift tax implications, the capital gains consequences, and the creditor exposure that comes with it. Patricia, the woman from our story at the beginning, eventually resolved her situation, but it cost her nearly a year of uncertainty, thousands of dollars in legal fees, and a level of stress that no grieving widow should have to face. Her husband had done so many things right, but the deed, the one document he never thought to review, undid much of that care. You have time to make sure this does not happen to your family. That time is now, before anyone is grieving, before a title company is asking questions, before a judge needs to sort out what should have been simple. If you want to take the first step, start by finding your deed this week. Pull it out of your files, look up your county recorder online, or ask your attorney for a copy. Read how the ownership is listed, and then make a call to an estate planning attorney or elder law attorney in your state. If you found this video helpful, share it with the person in your family who keeps the paperwork, because the people who most need this information are often the ones who would never search for it on their own. And if you want me to go deeper on any of the topics we covered today, transfer on death deeds, the capital gains trap from adding children to a deed, how Medicaid looks at deed transfers, or how to find out if your deed has survivorship language, leave a comment and let me know. The next video in this series covers what happens to your house when it goes to probate, what the timeline looks like, what it costs, and what your family will face if you leave this unresolved. That one may be even more important than this one. Take care of your family's foundation, because no one else is going to do it for you.